Good afternoon, everyone. Welcome to the next of our Essential series. These are topical, engaging, and technical webinars on the world of wealth and wellness by leaders in the private client world. I'm Lottie, founder of the Jura Society Network and private client consultancy, focusing on women, wealth, and well-being. This afternoon, we're joined by Joe and Amy from Hunters Law, and over the next half hour, we'll be exploring the legal life cycle, even, of relationships. Please do ask any questions in the chat, and we'll have time for Q&A at the end. The session will be recorded, and I'm going to pass over to Joe and Amy, and they're going to deep dive into all of the wisdom that they have. Right.
Hi,
ladies.
Thanks, Lottie. Good afternoon, everyone. I'm Jo Carr-West, and this is Amy Scollin, my colleague at Hunters. We're partners in the family team at Hunters. And what we're going to be speaking to you today, about is the different stages of a relationship and what legal issues can arise, and what we've learned over our years of experience of working with these situations, some tips and tricks to help you along the way. So I'm going to hand over to Amy, who's going to start us off.
So the first stage of a relationship I want to talk about is dating. And by this, I mean an intimate personal relationship between a couple where they are not cohabiting. So this kind of relationship gives rise to no real rights and obligations and responsibilities in law. However, there is a piece of law that this relationship allows you access to, and that is an injunction. If you are dating and you are the victim of domestic abuse, if you're being harassed, pestered, subject to physical or emotional harm, you can go to the family court on the basis that you have been in an intimate personal relationship with the perpetrator for a significant period of time. And if your application is successful, you can achieve an injunction, which we call a non-molestation order. So thinking about this stage of the relationship, my big tip is listen to the red flags. Often when we're dealing with a divorcing client, we often have a chat and say, did you see the relationship breakdown come in? Were the reasons for the relationship breakdown evident at the start? And usually the answer is yes, unfortunately. So please do be aware, red flags they rarely go away.
Yeah, so I mean, one of the things that we were talking about when we were preparing this is what can help you to identify those red flags, and one of them might be around how you deal with money and how you share the cost of things, and whether you are under pressure to set up a joint bank account or to buy assets together. It's absolutely fine to do both of those things, but obviously if the behaviour around that is making you uncomfortable, then only do what you're comfortable with doing. Any money that you're putting into a joint bank account, even if you're not married, is going to be considered to be jointly owned 50-50, regardless of who's put in what. Once that's gone into a joint account, that's how it's looked at by a bank. Assets might be more difficult to sort out the ownership, but again, if you're buying an asset, it's quite hard to prove that it's not owned 50-50 if it's in joint names. I know a key asset that can come up in relationships is
pets, believe it or not. It's not unusual for a couple that's simply dating to get a pet together, and the pet will travel between houses. Pets in law are dealt with like a piece of property, so if you can prove ownership, then the pet is yours. But having such a property dispute is not cheap and it's not quick. So if you are dating and you are thinking of getting a pet, have the conversation at the outset as to what will happen, what will be the arrangements in the event of a relationship breakdown. So moving on to the next stage of a relationship, and that is cohabitation. So cohabitation is on the rise. It's the fastest growing type of family in the UK at the moment. There's been a 150% increase in cohabiting couples over the last 25 years, and the law just hasn't kept up. There's around 3.6 million cohabiting couples in the UK at the moment. So a cohabiting relationship gives no rise to financial obligations and responsibilities towards each other. It does allow you to seek an injunction like the one I spoke to before for a non-molestation order, to injunct a party from harassing you or pestering you. But if you're living together and you're the subject of abuse, you can obtain an injunction to exclude your cohabitee from the property for a particular period of time. Other than that, as I've said, there's no rights and responsibilities that arise from a cohabiting relationship, irrespective of how long that relationship has been. The need for reform is in the spotlight, thanks to the Shadow Attorney General, Emily Thornberry, stating at the Labour Party conference that Labour are committed to reforming cohabitation law. It was said that no woman should be forced to stay in an unhappy marriage or to marry because of fear of being in a financial predicament if the relationship ends. The House of Commons have also, the Women Inequalities Committee have also done a report which identifies that the current law is leaving women and children in a really vulnerable position. If you live in a property with your cohabitee and you have made a financial contribution to that property, or there's been an agreement that you can share in that property, then you can bring a property law claim to the family or the civil court. That claim will not be determined on fairness. That claim will be determined on what exactly was the financial contribution to the property and was there an intention to share.
Those claims can be really tricky to sort out. They're very expensive, they take a long time, and they're very technical in terms of the law that they're based on. So one of the things that we'd always encourage people to think about if they are moving into a property together, buying a property together, is to create a document called a declaration of trust, which from the outset sets out what people's intentions are around the ownership of the property. Equally, you could have a document called a deed of no interest, which would say this property is one person's only, and whatever happens, the other party is not going to acquire a financial or legal interest in it. Those types of documents can be expanded into a cohabitation agreement, which can set out a bit more about how you might regulate and deal with finances during the course of your relationship, and what you might do if that relationship breaks down. Again, remember that point that I made earlier about joint bank accounts. Contributions to joint bank accounts, even if they're not equivalent to each other, are going to be considered to have been equal, and it will be divided 50-50. And the most important thing is just to not get caught up in the common law marriage myth. So around 46% of cohabiting couples believe that they have got some form of legal relationship, despite not having gone through a ceremony of marriage that's going to give them financial claims if their relationship breaks down. It's not a thing. And that can be a very difficult conversation for us to have with people who come to us after potentially a very long relationship. So think about these things at the outset. Think about if you don't want to marry, what steps you can take to regulate the legal aspects and the financial aspects of your relationship. Extend that to thinking about what would happen if one of you were to die, what needs to be in your respective wills to protect your estates on death. Not very cheerful conversations, but important ones to have.
So this isn't really a stage of a relationship, this is more of a standalone relationship. I want to talk about a situation where there has been a child born from a relationship that is usually quite short, and there has been no marriage. In this kind of scenario, usually we see the child with the mother, and usually the mother is not financially independent, and she has a financial need for herself and the child. In this kind of scenario, we can help the mother bring a claim to the family court, but the claim is really limited. First of all, the claim for maintenance can only be accessed if the father is living abroad or is earning over 156,000 gross per annum. So if you can reach one of those two thresholds, you can make an application to court for maintenance, but the maintenance has got to be strictly for the child. It's a needs-based claim. You can also ask the court to make lump sums, usually to cover moving costs or decoration costs for the home, or for a particular reason that can be linked and justified to the child's needs. And you can also ask the court for settlement of property. By this I mean the mother and the child can ask the court for an order that they either live in a property owned by the non-resident father, or they live in a property which is paid for by him. These are really technical and difficult claims. They're some of the most difficult claims that we ever see. For a variety of reasons. The law's technical, they're usually really robustly defended, and there's usually an imbalance between the parties on lots of different areas. Wealth is one, also experience of the courts. Sometimes there's an age difference, a significant age difference and life experience difference between the parties. And usually one party can easily fund the defence of this claim, while the claimant really struggles to afford to bring the claim. So my top tip for this particular claim resulting from this relationship is to seek technical family law advice.
Okay, thanks. Obviously, quite often what crosses over with both a relationship in which people are living together, or the type of financial claims that might arise when they have a child together, is that there can be an engagement behind all of that. An engagement of itself doesn't give rise to any legal claims on the end of a relationship. There are very limited property claims that can be brought, and it's under a piece of legislation from 1882. So as you can imagine, we don't often see those arising in practice. I think I've seen one in my career to date. Normally the kind of types of claims we would see in if people are engaged are the types that we've just been talking about, the ones that you might have in relation to the ownership of property or in relation to a child. If somebody has given an engagement ring, that gift is an absolute outright gift. There is no right for the person who has paid for and given the ring to claim that back from the other person. The other person gets to keep that ring if the relationship breaks down. What engagement does lead to is the need to discuss a prenuptial agreement. In some situations, people might want to think about, do they want to sort of set out now what the financial arrangements might be if there's a divorce in future. For example, they might be aware that they're going to inherit assets from their family, and they might want to take steps to protect those inherited assets, or they might have come to the relationship with assets that they want to sort of ring fence and protect on divorce in future. Strictly, a prenuptial agreement is not binding on a court in this country, but if it's done properly from the outset, it will be given a huge amount of weight and be quite determinative for a judge if somebody brings a financial claim on a divorce. It's not going to stop someone from bringing that financial claim, but it's going to guide how a judge deals with it. In 2010, the Supreme Court decided in the case of Radmacher and Granatino that should be the appropriate approach. There's been sort of discussion subsequently about whether the law should be changed to make them binding, and there hasn't been a huge amount of appetite for that. That's something which I think is probably fairly constantly under review, but we are where we are at the moment, which is that if we're going to put a prenuptial agreement in place, we have to make sure that it hits the relevant criteria. So it needs to be freely entered into by both parties. They both need to understand what they're doing. They both need to have had proper time to consider it and to digest the terms of the agreement. There needs to be full financial disclosure from both parties. Both parties need to have legal advice, and that has to be independent legal advice on both sides. It's really important to avoid that sort of pressure point, and one way to deal with that is to ensure that the agreement is entered into at least 3 or 4 weeks before a wedding takes place. We do sometimes see them much more close to the wedding day, but it's really, really not ideal for somebody to be signing in the days leading up to the wedding itself. Most importantly, perhaps, is that the agreement needs to try and anticipate what people's needs are going to be on divorce, what their financial needs are going to be. Those will be informed by the standard of living that people will have during the marriage, and they need to, whilst we wouldn't commonly provide for children in a prenuptial agreement and make the financial provision set in stone for children, you sort of anticipate what that lifestyle might look like if there are children and how that might impact the financial needs. So if all of those steps are properly taken, we're pretty confident that we can create a quite good insurance policy with a prenuptial agreement.
So tips from our practice. Well, firstly, it's quite common in London, at least in all the prenups I see, for the financially stronger party to pay for the financially weaker party's costs. I don't think I've had any resistance when I've been acting for the financially weaker party to a request that I've made for my costs to be paid. And the reason for that is because it's sensible. It takes away the financial pressure of actually getting the agreement done, and it opens the door to have a proper, thorough negotiation to exchange financial information in a timely way and to properly consider it. This disclosure, as Jo said, it's an important benchmark to making the prenuptial agreement more robust. And usually the better the negotiation, the more robust the agreement will be at the end of the day. The case law coming through the courts is that, well, it's clear that judges want to uphold these prenuptial agreements if they are fair. And therefore the top tip is do not sign a prenup thinking that you will deal with it later. If you sign a prenuptial agreement, you can expect to be held to its terms, and that is a very sensible way to proceed. Enter into it expecting it to be upheld in the event of divorce.
Yeah, absolutely, because sometimes you hear people saying, oh well, it's not worth the paper it's written on, so I can sign anything. That's just not the right way to approach it. They're really, really difficult conversations for clients to have, and we'd always encourage people to speak to their partner about what's going into the agreement, why it's going into the agreement, what the basis is, and the earlier you can have those conversations, the better. Don't leave it to the last couple of months before the wedding. Lots of people do, of course, that's fine, we can deal with it. But it's having those conversations at the outset over a longer period of time just makes them a bit easier. I think people can often feel like they're trying to send out their wedding invitations, plan the table arrangements and the seating plan, and also kind of work out what their divorce arrangements are going to be at the same time. So just trying to separate out the processes really, really helps. Be realistic about what can go into a prenuptial agreement. We don't have the sort of US style glamorous clauses that might say that if one party cheats on the other party, that has financial implications. I think there's also sort of apocryphally clauses about people gaining weight and things like that. All of our clauses that we put into prenuptial agreements are very straight-laced and around the financial arrangements that a court can deal with on a divorce. Going back to the pets points, you can deal with what's going to happen with the pet in a prenuptial agreement. Maybe think about that as part of the discussions as well. But I think the best advice that we can give people that's a sort of non-legal advice, good top tip, is have the conversations. And actually having those conversations is a really good indication for how you might deal with discussing the finances during the course of your marriage. If you can negotiate a prenuptial agreement, you can pretty much negotiate any financial difficulties that are going to come your way when you're married.
Absolutely. So the next stage of the relationship is the marriage itself. So the ceremony of marriage, provided it meets the legal formalities, it is the marriage ceremony that creates the financial obligations on you to your spouse. It creates an obligation to financially maintain each other. A few years ago, we had a big case go through the English High Court as to whether a Sharia marriage, a religious marriage, which didn't meet the civil English formalities, was a valid marriage, and it wasn't. Religious marriages in themselves will not be considered valid marriages unless they also meet the civil formalities. If you are getting married abroad, my big tip is to make sure that you get the appropriate advice in the country that you're marrying in, to make sure that your wedding will meet the formalities in that country. If a marriage is entered into validly in a foreign country, it will be recognised in the English courts. There was a famous case, Mick Jagger and Jerry Hall, who got married in Bali, and their marriage on a beach did not meet the Indonesian legal requirements, and therefore it was not considered by the English court to be a valid marriage.
Okay, so I'm just going to come back a bit to the idea of domestic abuse. It might feel like a sort of slightly strange one to put in here, but we just want to be really clear that it can be at any stage of a relationship. But it's quite important to think about it at this stage, because I'm going to talk a little bit about how the courts approach it when considering marriage, when considering a divorce. Just to put that into some context, the statistics on domestic abuse are really shocking. So in the year ending March 2023, the Crime Survey of England and Wales estimated that 2.1 million adults, 1.4 million of whom were women, had experienced domestic abuse during the course of the 12 months preceding that. We've all heard the really shocking statistics about people who are killed by their partners or their former partners, and roughly that's 2 women a week and 2 men a month. That's how it sort of boils down when you look at the statistics overall. So it's out there. It's a huge issue. We as family lawyers come across it day in, day out, and there are many different degrees of domestic abuse. There are many different experiences of domestic abuse, and we always have to do a sort of quite difficult balancing act about how we deal with that. We've talked a little bit about the types of injunctions and the ways in which we can protect people from domestic abuse. But one significant way in which it manifests itself is the financial consequences of it. And in that area, potentially the court, some people might consider it not doing enough to recognise the very significant financial impact that it has. When a court is deciding what financial orders, what financial arrangements should be put in place after a divorce, one of the issues that they need to take into account is whether there has been any conduct between the parties that they need to consider, or that it would be inequitable for them to disregard. But the threshold for when that is taken into account is very high. So the level of domestic abuse has to be exceptional and to have caused some financial loss for it to be given any real weight within the way in which you might sort out the financial proceedings. So, for example, attempted murder, sexual assault of children, various other very high impact things might be taken into account, but there are many examples as well of where it has not been taken into account, where I think people would be quite shocked to feel that a court has been able to just make financial arrangements between two parties who are divorcing without considering what impact it has. What we see quite often is the sort of financial consequences that it causes when somebody has decided to leave a marriage, and the financial position that they are in at that point in time, and what the impact on them then is for trying to unravel and unpick their relationship.
So some tips if you are thinking of leaving an abusive relationship. Well, first of all, we know that it's not an easy thing to do. I think the stats say it takes a victim 6 years to leave an abusive relationship, which is horrendous. My biggest tip is to plan and to make sure that you have got some access to cash. You will need it, although the court has the power, I mentioned it earlier on, to exclude a perpetrator from the family home. This is really quite an expensive application. It's not all that quick. It can take about 3 weeks to get the order, and that order is never usually made behind the perpetrator's back. The perpetrator has to have notice of that, and there's got to be a hearing, which can be all too dangerous and too drawn out for the victim. So if you have access to cash, you can get yourself in rented accommodation, and you can instruct lawyers. So that's my key point. My other point is stay connected to your friends and family throughout the relationship. Anybody can be a victim of domestic abuse. It's no reflection of you, your intelligence, your capabilities. It happens to anybody, and we see people from all walks of life. You're the victim, it's not your fault. The perpetrator will often try to isolate the victim from their friends and family, so staying connected to them is just really important.
We've sort of been framing a lot of this around divorce, which is perhaps the sort of next stage, hopefully not an inevitable stage of a relationship. A divorce itself is relatively straightforward. You hear a lot about in the sort of media about sort of quickie divorces and things. I don't think that really does the system that much justice, but it is now, after changes in the law in the last couple of years, quite a straightforward thing to do. And effectively what you're doing is converting what was a marriage certificate into a divorce certificate. You have to have been married for 1 year to be able to legally start a divorce process, and it is now an online application that can either be pursued by one party to the marriage, informing the court that the marriage is broken down irretrievably. You have to establish that the court has the jurisdiction in this country to deal with the divorce, and there are lots of ways in which that jurisdiction can be established, but one of them, the main one, is that you both are habitually resident in this country. And you have to have your marriage certificate, and you effectively say to the court, here is my online application, a little bit like applying for anything through a government website. And people can do that by themselves. We can do it for them, but in this day and age, it's quite a quick and easy process to do. The second part of it is that people can do it jointly. So if a marriage has just broken down in a way that everyone finds very sad, but without the sort of acrimony and conflict, quite often people are issuing what's called a joint application for divorce, both of them going to the court and saying, our marriage is broken down and we want to get divorced. Roughly speaking, it takes about 6 months to get from the point of issuing a divorce application to the point at which the court makes what's called a final order of divorce, which legally ends the marriage, and there's various steps along the way. But the main focus for us as lawyers, once that process has been initiated, is to consider what the financial arrangements are going to be on divorce. And that is where most people getting divorced spend the time and the energy and the emotional stress, because, as I say, the divorce process is actually relatively straightforward. It's the finances where things get tricky.
So I won't spend too long doing it, but I will summarise the court's approach to dealing with the matrimonial finances. It's a discretionary process. So the ultimate award really does depend on your one judge and his application of the law and how he sees the evidence before him. But there is a two-stage approach to finance proceedings. The first is to understand what assets there are to the marriage and what the parties' earning capacities are. And then there's secondly the distribution. How should a judge distribute the assets between the parties? The objective of the judge is fairness, to achieve a fair result. And the judge will embark on this process by having a look at what we call the Section 25 factors. These are a list of factors that are set out in statute that the judge has to consider when making an award and justifying what he or she thinks is a fair distribution. There are three main principles at play. Needs, and the vast majority of cases, even in fairly big money cases, are argued and justified on need. The second is compensation. This is really a very rare thing indeed in the cases that we see. Well, the cases before the court, there's only been one case recently. And then the thirdly is sharing. So sharing sounds quite easy. In the event of a long marriage, the starting point is that the assets should be shared equally. But this principle applies to matrimonial assets. So these are assets which have been generated during the marriage, usually by the efforts of both parties. There is a category of assets called non-matrimonial assets, and these are assets that are usually brought into the marriage by one party, or assets which have been generated after separation, or inheritances. Often there's quite significant arguments about the classification of the assets, because it really does have an impact, because as I say, the starting point is equal sharing in relation to matrimonial. So the financially weaker party is often trying to get as many assets as possible in that matrimonial category. Once you've done the exercise of quantifying what is there and then applying the sharing principle, you then ask yourself whether that is enough to meet need. If it's not, then you can run a case for more than your equal share of the matrimonial assets if you can justify it on the basis of needs. Now, needs is a really elastic concept. It's a concept that gives rise to hours and hours and hours of argument. And needs for one person can be entirely different to the financial needs of another person. Much depends on the wealth to the marriage, the financial obligations and the standard of living, also the age of the parties, and whether they've got any disability. If your needs argument if you can demonstrate that your needs are greater than your entitlement on a sharing award, the judge will make the needs award even though it is higher, and even if the effect of that is that non-matrimonial assets have to be invaded. I think that's a sufficient summary of what is quite a complicated area.
So I suppose the question is how, hearing what Amy said about what's taken into account and how things are worked out, what is the process by which that happens? And there are lots and lots of different options. So it can range from people sorting it out around the kitchen table, maybe having a bit of legal advice behind the scenes if things are relatively good-natured. If there's high conflict or there are real points of difference between people on how things get sorted out, then the sort of nuclear end of the spectrum is a full-blown court process at the end of which a judge makes a decision. But there's lots and lots of different sort of shades of grey and different methods along the spectrum between those two points. We quite routinely see people negotiating between solicitors and then using different sort of techniques, maybe sort of private hearings in which a private judge is employed to give both parties a confidential indication about how things might get sorted out that you can then use to negotiate. People go to mediation and they use a neutral third party to help them mediate. And that would be a specialist in family law who's able to provide them with some context and help inform those discussions. And we're seeing an increase in the amount of cases that go through arbitration, which is effectively a private court system in which you select a specialist judge, and the determination they make at the end of the arbitration is binding on the party. When you're sort of at the beginning of that process, it can seem like quite binary choices. You either have to go down one route or another route. And one of the things I would always say to clients is pick and choose the bits that are going to work for you, and that might change and evolve as the case goes on. So we might start the case off on one trajectory, but always being open-minded, thinking, well, what other strategy, what other technique or process could we use, whether that's to resolve a discrete point or to resolve the whole case. There's always some kind of jumping off points. There's always the opportunity to try and negotiate. And the court rules have changed very recently to increase the emphasis on out-of-court, non-court dispute resolution processes. So there is an increasing obligation on parties to try and sort things out without going to the court itself. Whichever route people go down, it's a hugely daunting process. So starting slowly, building up, putting together information at the outset helps people to feel in control and a bit less overwhelmed by what's to come. So trying to put together a budget of what your outgoings might be, and we use some software to help with that, or thinking through, where are you going to live? What does that look like? How much does that cost? How can that be afforded? What mortgage capacity might I have? Just trying to get some of the sort of fundamental bits of information under your belt at the outset, I think, is just a very reassuring, settling process that makes people feel in control, whatever then follows from that.
I agree. I also think a tip is to consider early and generous offers seriously, and give them proper consideration, because often there's a period immediately following the breakdown of the relationship where parties perhaps feel guilty and remorseful of reasons for the breakdown of the relationship, and it's not uncommon to see a generous early offer being made. Don't dismiss that, give that proper weight, because in my experience, parties' positions harden against each other the longer the process. Also, the longer the process, the more money that's been spent on legal fees, and that might necessitate a stepping down in the financial provision that each party prepared to offer each other.
It also means that there's more to, the more you've invested in legal costs, the more reason there is to fight about what the outcome is. Both parties having a good lawyer really, really helps. And being realistic about how much that's going to cost and where that comes from. It's often quite a good idea at the beginning of a case to think, okay, both parties are going to spend money on legal fees. Let's set aside a pot that each party can have access to meet their legal fees at the outset. And just being sensible about that.
It's definitely an investment. And parties should see it as an investment. Divorcing parties that are quite used to obtaining professional advice, I think, are able to understand the investment aspect of professional services more easily than others that do not regularly take professional advice.
One of the things that I always say to people in the initial meetings I have with them is, how do you want to look back on this process in 5 years' time? And it's a very difficult question to answer. But how do you want to look back and see that you've conducted this process? Do you want to come out of this feeling like you did it constructively and in a dignified way, or do you want to come out of it feeling like you fought for everything that you needed? And there's different reasons for thinking that having those two different views, and everyone is different. But I think from the outset, having a very kind of clear view about how you want to look back on the process is actually really, really helpful. And most people do say, I want to feel like I did the right thing. I want to feel like I was strong and that I held my own position, but that I was constructive, and that we didn't end up being enemies. And that can be quite a useful kind of touchstone to keep coming back to during the course of the proceedings.
Just picking up on that, Joanna, often you are not wholly in control of what the process is going to look like. Much depends on the personality of your partner. So as much as you might have the best intentions to want to look back and think that you had a constructive divorce, that's often not entirely in your gift.
But you can control your own behaviour, and quite often being the person who rises above things is actually quite a valuable place to be. But difficult. I totally agree.
Another tip is divorce coaches. There's a huge number out there in the market. My top tip is to go with somebody that has been recommended to you either by your own solicitor or by a friend who has actually used them. Another tip, be aware of well-meaning friends and family with their own stories about what their divorce looked like, or what they think that you should or should not do. You're paying, if you're instructing a specialist family lawyer, you will be paying good money. The advice that you're getting is in your interests, in your own best interests. It's independent, and you should follow your own lawyer's advice rather than well-meaning friends and family.
And we're not just saying that because we're the lawyers, but it's a bit like being ill, isn't it? If you start Googling your symptoms, you can come up with a big range of online advice that is not necessarily always helpful.
My final tip in a divorce situation is, as tempting as it might feel, do not hack into your spouse's computer, email account, Facebook, in order to hunt for information that you think might help your divorce. That is unlawful. It breaches your spouse's rights to privacy, and there could be serious consequences. Allow your lawyer time to get the relevant information and to pursue information in a lawful manner.
I'm just going to add one more kind of top tip that comes from experience, which I know that you'll agree with. We can't change, and the divorce process will not change somebody. So all of the worst characteristics that a partner has will come out during the divorce process, and preparing yourself for that and protecting yourself. And that can be, the divorce coach can help with that. We can help with that, but not expecting to go into a divorce process and thinking that you're going to get a different type of person on the other end of the proceedings, which is why it comes back to my thought process about what is it that you want, how do you want to have behaved and to have conducted things.
So the final chapter in the life cycle is death. If there is a death of one of the spouses whilst married, and there's no children and no will, then the surviving spouse will be entitled to all of the estate. If there are children, a spouse, children and no will, then the spouse isn't entitled to everything, as many people assume. The spouse is entitled to personal possessions, a cash legacy of about £322,000, and then the remainder of the estate is split in a not straightforward way between the spouse and the children. If there is a death following divorce, the divorced spouse is not entitled to anything under the intestacy rules. And if there is a will, if that mentions the former spouse's name, then that is read as though it is those clauses completely void.
So we can't emphasize enough that it's really, really important to make a will, to have some advice about the tax planning for your estate, and then to keep that will under review and updated to reflect your circumstances, particularly if those change on divorce.
So that's all we have for you today. It might be that Lottie has some questions for us. Hi. Lottie, I'm afraid you're on mute.
Sorry, I should know this by now. Thank you both. Amazing journey through the life cycle of a relationship. Sensible communication throughout, I think, is so key. And so many, newly engaged or newlyweds are in this haze of rose-tinted wonder. And actually, there's so much of that sensible hat stuff that they don't want to think about. But it's so important later down the line, because the person you marry today might not be that same person in 20 years' time as well. So I think it is really important to go in, maybe even look at what their parents' relationships are and things like that. So you might be able to get a little bit of a hint of actually what might happen if anything acrimonious were to come out of it. So thank you so much about, really highlighting open dialogue about finances and obligations. So a couple of questions. What is the difference then between a pre and a post-nup? Are they the same thing, just different time? What is it?
Shall I take this? So they are exactly the same type of agreement, but a post-nuptial agreement is one that you would enter into after you have married. And so we commonly see those rising. That point that I was mentioning about it not being ideal to be signing a prenuptial agreement on the way to the church. Quite often, if time has become a little bit tight to sign the prenuptial agreement and finalise it before the marriage takes place, we might advise people to have a post-nuptial agreement in equivalent terms shortly after the marriage takes place. So you have a prenuptial and a post-nuptial agreement in that situation. The reason for that dates back to a judgment that said that a court was more likely to uphold a post-nuptial agreement than a prenuptial agreement. So it's seen as a sort of belt and braces style approach in that situation. Another reason that people might have a post-nuptial agreement would be if one party is about to inherit assets, perhaps, and wants to take that step of trying to sort of protect and ring fence those assets, and didn't do it before they got married, either because the point in time that they got married or those assets weren't even in contemplation at that point. So you could have a post-nuptial agreement at that point. The process is the same. The factors, the need to take legal advice to do it without pressure, all of those things are the same. People sometimes have post-nuptial agreements when their relationship has become very difficult and they've perhaps thought about separating and divorce and then have decided to remain together. They might have a post-nuptial agreement at that point to sort of reset things. So there's commonly three scenarios in which we'd see them, but the same process, the same law applies.
So I'm just thinking, sorry, curveball. So say you are in a dysfunctional relationship, marriage, you've then done the post-nup because you're like, okay, we're not going to actually get divorced, but we are on that journey. If you're then in a new relationship with somebody else, so you're separated, but you're not divorced, would that new relationship impact what the outcome of the settlement might look like financially? Sorry.
It could do. So if that relationship was not necessarily anticipated at the time of the post-nuptial agreement, it could be used by the other party to suggest that the terms of the post-nuptial agreement are not the right ones if a divorce takes place. Because of the challenges around sort of cohabitation and the lack of legal rights if you're not married, the status of a new relationship and the impact that it has on the types of orders and arrangements that a court makes on divorce is a bit of a sort of controversial area in some respects, because the court says actually that person doesn't have the same claims against their new partner as they have against their former spouse. It doesn't necessarily completely sort of wipe out the need for the spouse to provide financial support or share assets. I think it's quite interesting. I mean, it's a fairly dated piece of law. It'll be quite interesting to see if that gets challenged, I think, over the next few years. But my guess is that until there is a change in cohabitation law, there isn't going to be a lot of appetite in the court system to take any controversial decisions.
Interesting. Okay, and then in that whole post-separation murky territory, what if you then are super high earning, you've just sold your business, you are in that post-separation asset generation mode? Matrimonial, non-matrimonial?
So earnings post-separation and assets acquired as a result of those earnings are, I can say, confidence, non-matrimonial.
Interesting.
Earnings or increasing asset value and the asset was present during the marriage, it's harder to be confident. It much depends on, I sound like a typical lawyer, much depends on the place. So that usually the the big cases that we've seen go through the courts are where there has been a business separation, and then that business has had a big bump in value post-separation. And much depends on the judge's analysis, but it really is an area, matrimonial, non-matrimonial, where there can be many legal arguments, because it's not clear cut. The courts can't give us a formula as to what is matrimonial, what is non-matrimonial in this circumstance. In the circumstance where the increase has straddled separation and marriage, but earnings, we are pretty clear. Earnings post-separation and non-matrimonial.
Interesting. And then we're seeing a rise of trad wives. So there's, I don't know if anyone's on Instagram wasting time on there. Traditional wives, big boost, especially in the US. But actually, if they are not working during a marriage, will they get less? Or if they've earned less, if we're going back to those traditional male-female roles, gender stereotypes, will that impact on their?
Well, the law is clear that there's no place for discrimination between the roles of a typical traditional roles for husband or wife in matrimonial finance law. The courts have for a long time recognised the contribution of a non-earning spouse in helping bring up the children, having the children, bringing up the children, looking after the home, and supporting usually the husband going out to work. So in theory, there is no discrimination at all. But the reality is that it can be very difficult to divorce a traditional wife who is in their mid-50s. Their husband's earning capacity is petering down, and the income really isn't there to support the standard of living during the marriage. And the reality is that traditionally, husbands who have had a long earning career, they can bounce back financially from divorce much more easy than a traditional wife, especially one who's 50 plus, in my view. It's a really difficult time.
And I think that is something as well that is a generational consideration.
Yeah, absolutely.
Thank you. Well, thank you both. I don't know if you have any final closing comments. There's lots of food for thought there. Thank you so much.
Just feel free to contact us if they have any questions on LinkedIn, and we'll be happy to answer them.
Thank you all. Thank you for all tuning in as well, and anybody who's watching this on the replay. To Joe and Amy, always welcome to answer any questions that you might have. So thank you both.
Thank you. Thank you, Lottie.
Bye.
Bye-bye.